the orangutan
Why would it
sentences
not
do.
be sufficient to say miscarriage of justice on the assumption that everybody who's going to be applying that standard knows it's a high bar, has seen it before, has thought about it before? The idea of defining it into 3 discrete situations is not usually what we do when we speak of miscarriages of justice, and yet, everybody gets that it's a high bar.
The problem with setting the high bar is not that we're concerned that judges won't know what constitutes a miscarriage of justice. The problem is that defendants won't know, and they may well think that their case does present the miscarriage of justice, and then we have to litigate it, and that deprives us of the benefit of the bargain, which was to not have to litigate it.
That's right, but if that's the case, that kind of challenge can be easily dismissed. I mean, I guess I wouldn't think that would take very much of anybody's time.
We do end up having to brief the merits of these disputes because courts will sometimes just ask for more briefing. The circuits that have this more open-ended open-ended exception, they do report a more serious burden to litigate it. So we do think that capturing the discrete kind of buckets of cases that do seem to give everyone concern, and I think those 3 do really capture the universe of what people are worried about, the, categorically impermissible sentence or categorically impermissible condition, the sentenced by an orangutan, the race-based sentence. I think that is the universe, and so just limiting it to those 3 and making very clear what those exceptions are, and then applying them to this case rather than signaling to lower courts and litigants that this is a borderline case, I think would be far preferable.